Hello everyone, I'm Bob Sturbank. I'm the City Attorney for the City of Snoqualmie. I'm here to talk to you today about Muni Law 101, the organic authority of cities, the separation of power, and the role of the City Attorney. Before I dive into the details, a little bit about me. I've been practicing as an attorney in Washington State for 30 years, and I've been the City Attorney for the City of Snoqualmie since December 2013. If you're watching this, you've probably already seen the more whiz-bang presentations from fire and police and public works. They have vehicles and toys and lots of fancy equipment. As a lawyer, I don't have any of that, but I do have with me here today my trusty assistant, Quid Pro Quo. So we'll start with that. And just remember, if you're ever in an argument with a lawyer, they're not arguing, they're just explaining why they're right. So why should we talk about Muni Law? Well, first of all, it's not taught in school. If this were the live in-person presentation, at this point I'd ask for a show of hands how many people learned about the way their cities or counties functioned in school, and I could count on one hand the number of folks who would say yes. It's true there's always been some educational programming out there. Some of you will remember, if you grew up after the 1970s, I'm just a bill on Capitol Hill, but that's the federal process. And even the other parodies that are out there, again, are on the federal process. So it's important here to talk about seriously why municipal law should be focused on. And that's because it controls what a city can or can't do, how it can be done, and who is authorized or required to do it. And when we find ourselves in a political disagreement, which is happening more and more these days, it's often helpful, if not necessary, to remember the municipal law rules of the road. So let's get into the details. What's a city? A city or a town is a corporation for municipal purposes, or in short, a municipal corporation. And that's the lexicon that is given to us by our state constitution in Article 11, Section 10. Why incorporate? Well, incorporation provides local control. Snoqualmie incorporated as a town way back in 1903, when it was quite a long distance to travel to Seattle, the county seat at the time, in order to conduct business with King County, which was, prior to incorporation, the governing authority for folks who lived up in the valley. Local control over what? What did the city gain by incorporating? Well, take a look at the ultra-local subjects of the first 200 ordinances, and they span the basics from police and courts and sidewalks to streets to the more esoteric or archaic, perhaps, peddlers, hawkers, vendors, saloons, dog licenses, and in an early example, the belling of cows and horses. An early ordinance made it illegal to put a bell on your horse or cow prior to a certain hour in the morning, 6 a.m. or after. And in that respect, although it may sound quaint, it echoes, or it has some modern day echoes in the city's current noise ordinances, which regulate when construction vehicles can start and stop and when other noises can be engaged in or created such that they be potentially disturbing other residents of the city. And let's not forget the classic billiards and pool. And maybe in a case of art imitating life, those of you who are musical theater fans will remember Robert Preston's depiction of Professor Harold Hill singing about "You got trouble right here in River City," with as shown in the photo here, the potential for youth to see or participate in pool and billiards. And a 1920 Town of Snoqualmie ordinance made it illegal, made it a crime, a misdemeanor for anyone under the age of 18 to go into an establishment that featured billiards or pool, and also made it illegal and a misdemeanor for anyone to allow that, a person who ran an establishment. That ordinance, although old, is still on the books today. So that's the kind of local control that is gained by incorporating as a city or town. What else can a city do? Well, let's turn to the Washington State Constitution. It says a lot about counties, but not a lot in detail about cities. But Article 11, Section 10 does provide basic city operating authority. And it says that the legislature, by general laws, and that's a phrase that appears elsewhere in the Constitution, shall provide for incorporation, organization, and classification in proportion to population of cities and towns. And that city or towns, either previously or later organized, and all charters framed or adopted by authority of the Constitution are subject to and controlled by the general laws. So what does that mean? In concept, at the time, it meant cities are creatures of the legislature, and that they had no more and no less power than the legislature gave them. And so at the time, within the unincorporated area of a county, the county and state laws applied. Within city limits, city and state laws applied, and county laws do not apply unless the legislature said that a particular county law applied within cities as well. There are certain statutes relating with some relevance today to public health and the authority of the county health official. Those laws apply not just in the county, but in the city of Snoqualmie and other cities as well. Classification of cities. I mentioned the classification in proportion to population. In 1890, the legislature provided 4 separate classifications based on population. First-class cities over 15,000, second-class, then third-class cities over 1,500, and towns like Snoqualmie, when it incorporated, whose population was under 1,500 people. In 1994, the legislature modernized that a bit, eliminated third-class cities, and adjusted the population classifications upwards a little bit, and you'll see those featured on the slides. Now, turn the clock forward. In 1967, there was a big change when the legislature adopted the Optional Municipal Code, which is codified in Title 35A of the Revised Code of Washington, or the RCW. If I refer to RCW, I'm talking about the state laws codified in the Revised Code. The Optional Municipal Code gave to cities who chose to operate under it all powers possible for a city or town to have under the Constitution, and not specifically denied to those cities by law. And so essentially took the rule that we talked about a few moments ago and reversed it. So cities no longer have only those powers specifically given to them by the legislature. Instead, they have all powers possible to have under the state constitution, unless those powers are specifically taken to the legislature. Cities with a charter upon the adoption of the Optional Municipal Code, for example, Seattle, Tacoma, retained those charters and became what's known as a charter code city. A city or town without a charter on adoption of the Optional Municipal Code became a non-charter code city. And Snoqualmie became a non-charter code city in 1976, and you can see that authority in the adopted Snoqualmie Municipal Code 1.08.010. Code cities are further broken down into 2 different types. There is the mayor-council, or commonly referred to as the strong mayor form, where the mayor is separately elected and not a member of the council. The mayor and council have separately defined powers and duties, and that lead to a separation of powers doctrine. Stay tuned for more detail on that later in this presentation. The second classification or form of code city is the council manager form of government. Under that form, the mayor is just one member of the city council who is chosen by the city council, not specifically by the voters. In a council manager form of government, the mayor chairs the council meetings and performs ceremonial duties for the city, but the city operations are run by a professional city manager hired by the council, and the manager reports to the council under that form. The city of Snoqualmie operates under the mayor-council form of code city government. And how do we know that? Again, that's reflected in the adopted Snoqualmie Municipal Code in 1.08.010. Most Washington cities are code cities operating under the Optional Municipal Code. A slight majority utilize the mayor-council form of government. So what are some of the key differences? I mentioned a few between the council manager form and the mayor-council form. So first, under the strong mayor form of government, the mayor is effectively the city's CEO, chief executive officer, has the hiring and firing authority, exercises general supervision over all city government and city interests, and that's reflected in the state statute in 35A 12-100. By contrast, under the council manager form of government, as I mentioned, the mayor has no administrative duties. He or she acts only as the head of the city for ceremonial purposes, or in the rare and we hope unlikely event of being appointed by the governor to under military law. Under the council manager form of government, the mayor participates as a full member of the city council and votes on all matters presented to the council, whereas under the strong mayor form of government, the mayor is not a part of council, does not vote on any matter in front of the council except in the event of a tie council vote, and even then only on limited categories of matters which may not include passage of an ordinance, the grant or revocation of a franchise, or the resolution for the payment of money. As I mentioned, the mayor is the CEO and may hire a city administrator if authorized by the council, but that city administrator reports to and works for the mayor, not the city council. In the council manager form of government, the city council hires its own professional city manager, who then has hiring and firing authority and general supervision over city affairs, but the city manager reports directly to the city council. Under the council manager form of government, the separation of powers is enshrined in state statute. One statute, 35A 13-120, expressly prohibits the city council from interfering in the manager's administration of city business, and except that the council may remove a city manager by a specified process. By contrast, under the strong mayor form of government, the separation of powers is not explicitly codified, except to the extent that the powers exist by virtue of the delegation of specific powers to the mayor on the one hand and to the city council on the other, and I'll talk more about that in a moment. In a strong mayor form of government, the mayor may also veto ordinances passed by the council, but that veto may be overridden by a majority plus one of the entire council. In the city of Snoqualmie, with a 7-member city council, that means it takes 5 votes to override a mayoral veto. So how does a city govern, regardless of the classification? Or what happens when someone says, there ought to be a law? There are a variety of ways that governance happens in a city. First is ordinances, general and permanent laws and regulations that are adopted only by a majority vote of city council. Ordinances are in writing, they're numbered, they're filed by date and order of adoption, and they may, but are not required to be codified, that is, collected in one place, and including the various provisions of the ordinances that are adopted, amended, or subsequently repealed. In Snoqualmie, all ordinances of the council are codified in the Snoqualmie Municipal Code, which is organized by title, the major subject of the ordinances, chapters, breaking them down into more specific subcategories, and section. And so typically you'll see a reference title dot chapter dot section. The text of an ordinance or a summary of its contents is required to be published at least once in the city's official newspaper upon adoption and before the ordinance may become effective. Per statute, an ordinance can contain only one subject, and that subject needs to be expressed in the title. That's what's known as the subject and title rule, and it parallels a similar state constitutional provision that applies to state laws adopted by the legislature. And if you're familiar with any of the history involving Tim Eyman initiatives around the amount of license plate fees, some of those Eyman initiatives were struck down for violation of the subject and title rule because they included more than one subject. But back to ordinances. Ordinances must be presented to the mayor for signature. If the mayor vetoes an ordinance, it's returned to the city council with the mayor's written objections, and the council then reconsiders it and may override the veto with a majority plus one vote. If the mayor fails for 10 days to either sign or veto an ordinance, the ordinance nevertheless becomes valid without the mayor's signature or approval. An ordinance is required to be authenticated by the city clerk and recorded in the indexed book of all ordinances and resolutions. And in the case of Snoqualmie, where ordinances are codified, it's then included in the codified Snoqualmie Municipal Code. An ordinance takes effect 5 days after passage and publications, unless it's an ordinance adopted specifically for an emergency, in which case it may become effective immediately. But an emergency ordinance may not levy taxes, grant or renew or extend a franchise, or authorize the borrowing of money, such as the issuance of bonds. Otherwise, the effective date may be set as may be called for by state statute. Another option for governing are resolutions and motions. Resolutions are a written record of the council action on more temporary issues, and motions are simply an oral council action Neither a resolution or motion falls into the category of general and permanent, and therefore that's what distinguishes them from ordinances. Resolutions and motions are adopted by majority vote of the council, and the mayor may not veto a resolution or motion, but may break a tie on a resolution or motion unless it's a resolution for the payment of money. Resolutions are also in writing, numbered, and filed with the city clerk, but they're not codified. Motions may be reflected in writing only in the city council minutes, which are prepared by the city clerk and adopted by council at subsequent meetings following the action, which is memorialized in the minutes. Some actions can be taken by either an ordinance or a resolution or motion. There's not always a bright line. Resolutions and motions can be effective immediately, unlike an ordinance, as I've discussed previously. There's a third possible category of actions for governing, and that is initiative and referendum. If you're looking at my presentation online, you'll see a number of slides that provide a lot of detail on this topic. Those were prepared when initiative and referendum were a subject of greater conversation in Snoqualmie. I'll skip some of those details right now. Just a few things important to remember. First of all, initiative and referendum is not provided by the Constitution for cities, so it's available only if a city affirmatively elects to adopt that form of governance. Snoqualmie has not elected to do so, and so initiative and referendum doesn't apply within Snoqualmie. And last, there are a number of significant limitations on the power of initiative and referendum. A number of those limitations are set forth in the statute that governs the process. Others are reflected in decades of Washington appellate precedent. The bottom line of those limitations is it's very difficult to utilize initiative and referendum, and its exercise in other cities recently has been the subject of a lot of litigation that has resulted in striking the initiative and referendum as outside the bounds of authority. So it's a limited tool, but you may want to know that it's available under certain circumstances. And please refer to the presentation slides online for more detail. So I'll jump ahead here. I mentioned separation of powers a while back, and that's a topic that's been in the news more of late. Separation of powers is a judicial doctrine. There's no constitutional or statutory prohibition one way or the other, but similar principles apply, and it arises from the principle that the City Council is a legislative branch that has specifically defined powers, and I've got some subsequent slides with more of those detail that you can refer to online for the enumerated powers. Similarly, the mayor represents the executive branch, and the mayor has their own separately defined powers, also defined in similar slides. And what those provisions require in any given situation is not always clear. The separation of powers doctrine holds that each branch of government lacks authority to take actions that fundamentally intrude on the powers granted to another branch. To make this a little more complicated, statutory checks and balances, the mayoral veto, a city council veto override, add even more uncertainty to the mix. There's very little guidance in decided appellate cases. There isn't a single case that holds that some action did or did not violate the specific allocation of powers under Title 35A vis-a-vis the other branch. And so we often wind up in practice following what was informally established as the Anderson principle, articulated by my predecessor, longtime former city attorney Pat Anderson. And that is every mayor and city council invents their own version of the separation of powers doctrine and puts their own boundaries in place as to what delegation of authority to which branch the council and mayor are collectively comfortable with. I'll skip over the enumerated slides. You can refer to those online. A possible solution to the separation of powers conundrum lies in the principle of comity, which is defined as a state or atmosphere of mutual respect or harmony or mutual civility and respect, and apply those literally. It's also an informal principle that nations and states will extend certain courtesies to another nation or state, recognizing the validity and effect of their acts. You can apply that by analogy to a municipal government in Washington. And as we note here, comity, the principle, does not equal comedy. It's actually what's necessary to avoid it for those who are watching municipal government operations. Talk about some separation of power disputes in real life. In particular, disputes over police funding, and more particularly in the city of Seattle. If you've been following the news, you'll know that in late August, Mayor Durkin vetoed a series of city council budget revisions that would have resulted in the layoff of 100 police officers, would have slashed the salaries of police command staff, and directed $14 million in new funding to community organizations. On the heels of that, then Police Chief Carmen Best resigned. Was there an appeal to comedy after the fact? Yes. Mayor Durkin was quoted in the Seattle Times as saying, "The people expect us to work together," and indicating she had spoken to the council president, Lorena Gonzalez, on, quote, how to make changes in a more thoughtful, deliberate way. And what's really underlying this dispute is what actions will the police take, when will they take it, which is a topic generally assigned to the mayor and the police chief as in their executive functions. And we have a situation where, in response to public pressure and input, the council would like to try to exercise their own control over that. But the avenues available to the council are primarily financial, and so you see that action reflected in budget decisions because the council lacks the executive authority to direct the police department. So how's the exercise at comity working in Seattle? Well, stay tuned. Most recently, one group interested in affecting the outcome posted on its website, quote, "Tell the city council to stand strong, override the police budget veto," advocating for exercise of one of the statutory checks and balances. So stay tuned for the outcome of that. But if you watch it, you can see the separation of powers difficulties being worked out in real life and in real time. A little closer to home, Snoqualmie has its own separation of powers conversations, although perhaps less dramatic. In early April, in response to the pandemic, Mayor Larson issued an emergency proclamation, actually at the start of the pandemic. City Council followed with an ordinance that added to the mayor's emergency authority by authorizing the mayor to make those expenditures out of the general fund and backfill them by transferring funds out of the Fund 002, the contingency reserve fund that's been previously established by the council and funded by prior council budget actions. That's an example of the mayor and council coming to an agreement over how the mayor may exercise his executive authority to best respond to the emergency situation unfolding as a result of the COVID-19 pandemic. Similarly, after many months of deliberation and conversation, the council adopted a contracting and purchasing matrix that authorizes the mayor to make and execute certain contracts within specified dollar limits. And to allow the council to monitor the exercise of authority under that new system, the council imposed some regular reporting requirements that have the mayor providing oral and written reports to the city council on a regular basis regarding contracts that have been executed. Now, make no mistake, these outcomes, while perhaps representing a solid legislative and executive compromise, were not simple, and it took a fair amount of conversation and dialogue to enter into. But it is an example of where the different branches of government can and do on a regular basis work out how each can exercise their powers to facilitate the better operation and provision of governmental services to the public. Now, we should also talk a little bit about, for governing, staff roles. Management and professional staff have conceptually distinct roles. We talked about the city administrator, who exercises the mayor's authority under direction and supervision of only the mayor. And the appointment of city officers and employees is required to be made on the basis of ability and training or experience. That's called for by the state statute. The council can confirm certain appointments, but only when the council prescribes by ordinance. And in Snoqualmie, the city council has done so for the city administrator and all department head positions, including any future department head positions that may be created. And that's codified in SMC 2.64.010. The department directors have overall supervision of the day-to-day operation of their departments. They manage their division supervisors. They prepare recommended budgets and facility improvements for their departments, but all answer to the city administrator and ultimately to the mayor. There are 3 positions that are mandated by state law: the city attorney, the city clerk, and the city treasurer. The last 2 may be filled by the same person who serves as the clerk treasurer. In smaller cities, it's not uncommon to see that filled by a single person. Arguably, a 4th position, by dint of reference in the statutes, is also mandated, and that's the police chief. So what's my role? The role of the city attorney is a bit distinct from other staff. Ethical rules governing attorneys in Washington state mandate that the city attorney's duty runs to the client, which in this case is the municipal corporation that is the City of Snoqualmie. The duty doesn't run to the city council or to individual city council members, the mayor, or the city administrator, or individual city employees. And a lawyer who is employed by or retained by an organization represents the organization that acts through its duly authorized constituents, who are not voters, but who are actually the branches of government, the city council, the mayor, the city administrator, as the case may be. How does the city attorney fulfill that role? It requires me to impartially advise the individual branches of government concerning their respective actions, as those may be authorized by state law or city code, and with respect for any comity that is established between the branches, as reflected, for example, in ordinances, resolutions, or even just ongoing working relationships between the mayor and city council. Providing legal advice in this case and in this context requires knowledge of the state constitution, state statutes, federal laws and regulations, applicable case law, decisions of administrative boards on different topics, including the Growth Management Hearings Board, the Public Employee Relations Commission, and others, and familiarity with state and federal courts and decision makers. Sometimes the question comes up, can the city council hire its own attorney using city funds? The answer is, in general, absent special circumstances, no. Because case law establishes that when a municipal corporation has legal counsel who's charged with the duty of conducting the legal business of the government agency, any contracts with other attorneys for additional and extra services are void. There are special circumstances, as noted, and those include instances in which the mayor or town council is incapacitated, or the city attorney is incapacitated or refuses to act, or may be disqualified from acting in a given case by conflict of interest rules that are part of the ethical rules governing attorneys. And there's a few examples included in this more detailed slides in the PowerPoint on the web. And the case law does establish that if the council proceeds and hires its own outside counsel in the belief that special circumstances exist, the council must prevail on the underlying substantive legal issue in order to have the legal fees paid with public funds. So there's a certain amount of risk for a city council that chooses to proceed in that fashion, in that the council or individual council members may be, at the end of the day, liable for the expenditures if they don't prevail. So take all of this together, you may be scratching your head or a bit dizzy and asking yourself, is this any way to run a railroad? And back in 1998, the very first Snoqualmie City Administrator, Kim Wild, who was analogizing to our local railroad circumstances, said, is this any way to run a railroad? Here's some rules and things to keep in mind, and it's still good advice today. When catching a moving train, get up to speed in a hurry, turn very gradually, be sure the train stays on track, and listen to your city attorney who can help you figure out where the tracks are and where the sideboards on the tracks are. Everybody on the train winds up at the same station. It's always bad practice to fire the engineer in between stations, and there's little room in the engine room for the board of directors or the president who are better accommodated elsewhere on the train. And keep in mind the tracks don't end at the station, or even today But we have government laws, ordinances, regulations, and form of government in place so that we can perpetuate the provision of government services on into the future and beyond any one attorney, city council, or mayor. Thanks for hanging in there for this, and we appreciate your participation in Citizens Academy. Also on the presentation are my contact number and the other members of the City Legal Department staff. If you have any questions, feel free to give me a call or send us an email. Thanks.